Welcome back to the strains of London Rain's Hush and Whispers. London Rain are Cleopatra recording artists. They're currently working on their second album. I have the honor of managing them, and my producer today, and now that she's back from seeing 21 Pilots down in Anaheim, Laura Espinoza London, is the songwriter and lead guitar player, and just a tremendous asset to both the band and this show, and my legal office, quite frankly. So we're talking with our guest, Eve Wagner from Beverly Hills, an employment lawyer, and we're talking about a new employment regulation in Los Angeles, the city of Los Angeles, that is likely to spread throughout the state and probably in a number of other major metropolitan areas in the country. So, Eve, why don't you tell us about it?
So it's commonly referred to as ban the box. So what does that mean? That means that a lot of people have on job applications, a lot of employers, have you ever been convicted of a felony? So that has to be removed in the city of Los Angeles from the job application. And if you want to run a criminal background check in LA, first you have to give them an offer, and it can only be conditioned on that background check, nothing else. So once you give them that conditional offer, then you can run the background check, and if it pops up with something, then you have to do a written assessment and weigh whether or not that person really shouldn't be hired versus what the crime is. Give the applicant a copy of that written assessment, and they have an opportunity to respond to it, and then you have to reassess if they do respond before you make a decision as to whether you withdraw the offer. So it's getting very, very complicated in terms of how you deal with criminal convictions and whether you can hire or change your mind and decide, nope, sorry, we're not going to hire you after all. So there has been legislation proposed in California, so it would be statewide. It has not passed in years past, but we'll see. They're probably experimenting to see how it goes in LA City. There are other cities that have adopted similar ban-the-box ordinances, so stay tuned on that one.
No doubt, because California is the state that's at the forefront of changes in employment laws, and this seems a very logical extension. If you're old enough, like I am, to remember, you used to be able to ask about arrest, and then the laws changed and said you can't do that. You can only ask about convictions, and now you can't ask about convictions unless you've given an offer only conditioned on the background check. So prospective employees' privacy rights are really, really, really expanding, and I think I would expect to see this if California does it. Oh, we have a question from Chris in North Hills. We like to get to these questions as soon as we get them. What about teaching positions in state and federal jobs? Now, it's unclear. It's an email question, but I would imagine.
So that's probably governed by your collective bargaining agreement. So that's a little bit different. So depending on what the provisions of the collective bargaining agreement and what your union has negotiated for, that's what's going to govern.
Right. Just so you're clear, a collective bargaining agreement is the contract between a union representing employees in a particular unit or a particular federal or state agency or school district, and the school district or governmental entity, and they negotiate all the terms and conditions of employment, including basically the hiring practices, which sounds unusual because basically what they're doing is they're negotiating for people who are not even members at the time or not covered by the agreement at the time until they're hired. So it's unusual, but I think that's a good answer. And I think, so what we're saying is that law would apply only, I would imagine, in the city of Los Angeles, only to the city employees themselves. Private employers, interesting question. What position would you take on county employment? in LA
So
County.
ban the box applies to all employers within the city of Los Angeles, so not county. So if you're in the unincorporated area, ban the box wouldn't apply. But it's not just government employees; it's all employees within the city of Los Angeles.
But how about an employee working for the county of Los Angeles within the city?
Then they're going to be governed by it.
That's what I thought.
Yeah, but if you're outside of LA City, but just in LA County, that doesn't matter yet. And it's interesting while you're talking about that, because in the wage and hour context, we have minimum wage and sick leave. So California has a minimum wage and certain mandatory paid sick leave, and various cities now are adopting their own sick leave and minimum wage laws. So it's getting very, very complicated for employers, because they don't just have to follow state law. They have to determine, well, where are my employees working? So if you've got an employee working, let's say, sometimes in Santa Monica and sometimes in Los Angeles City, or LA County for that matter, because they have their own ordinance as well, you've got 3 different laws that apply, plus
And
the state.
Needless to say, they all differ, don't they?
Well, some are similar and some are don't. So you sort of figure, what is the broadest protection that could apply? That's your safest route to go, and give the employee that. So, for example, if in San Diego you've got a carryover for sick leave. So, in other words, you earn a certain amount of sick leave each year, and you can carry over a certain amount to the next year and the next year after that. They have a larger carryover than some other cities. So it's really interesting. It gets complicated for employers that have employees that work in more than one city.
Yes, it does.
So, and this is somewhat new. I mean, and like I said, I've been doing this for 30 years, and we really didn't have city, county, and state laws, wage and hour laws that differed.
Yes, and it also brings
and now you do.
And it brings in more enforcement agencies. I mean,
absolutely.
I had a case in the city and county of San Francisco about 10 years ago, and they have their own division that does nothing but deal with minimum wage violations. And you think, oh, if I pay the right amount, I'm clean and I don't have to worry about them. The answer is no, you're not, because they also enforce it for overtime, for rest periods, for meal periods. So they almost duplicate the jurisdiction of the state labor commissioner. And I'm sure,
absolutely.
Has LA, I would assume LA, the city of LA, has already got one in place.
It's interesting. I haven't seen anybody file within the city. It's still going. Labor commissioner. If it's certain claims or the EDD, and of course civil litigation. But those are, the labor commissioner still seems to be handling most of these if they're not going through private lawsuits. So it'd be interesting to see if you've got a minimum wage violation of the city ordinance and the county ordinance. Are you going to go multiple places? My guess is you're probably going to pick a lawsuit. That's the most lucrative.
Absolutely. Now, a good topic on the wage and hour question is, what is the role of the state labor commissioner? Often mislabeled as the, quote, labor board. I'm sure you hear that all the time, which it is not. The labor board is the National Labor Relations Board, which deals with representation and other union management issues. But what does the labor commission?
The labor commission's where you'd go for your typical wage and hour violations, so meal breaks, rest breaks, overtime. And any employee can go to the labor commission and file a claim, and it results first in a settlement conference and then goes to hearing. The Fair Employment and Housing Act is governed by a different commission. So the Labor Commission is dealing with the wage and hour.
Now, what happens if, let's say I work for the Acme Company and I have a wage claim. I don't think I've been paid the overtime that I'm owed. And I go down Take me through the process at the Labor Commissioner. What happens when after I go down and file the claim?
So you go in, and they're actually very, very helpful to employees. So they will walk you through the paperwork and ask you if you have any other issues. So, for example, if you go and say, I didn't get my meal breaks, they'll ask you, well, did you get your rest breaks and did you get paid your overtime? Then let's say you file your claim. The next thing that happens is the employer's notified, and you're notified of a conference date. And at the conference, you go down, and the Labor Commissioner explains the claims and gives the parties an opportunity to see if they want to settle the claim. And if you don't settle the claim, then some of them are about a year out now. About a year later, you have a hearing. And then it's like a mini trial, in a sense. Testimony is taken from both sides. You can have a lawyer, or you can go by yourself. And then there's a decision which can be appealed. And it is what's called de novo, which means you start over again with a new hearing. But if you have an attorney at that point and the employee wins, the employer has to pay the attorney's fees.
Which is good for the employee, and it allows him or her to take advantage of the right to have an attorney, because you can be guaranteed that the employer is going to have one.
Yeah, I mean, the nice thing about the Labor Commission for employees is you don't need a lawyer initially. You can go down there, and they will advocate for you, basically, through the conference process until you get to the hearing. And then at the hearing, it's like I said, a mini trial where they're going to listen to both sides, take evidence, both documentary and testimony, and issue a ruling. But it's a simple process as opposed to filing a lawsuit where you have your deposition taken and there's a lot of written discovery and ultimately a jury trial. And then a lot of employers have arbitration agreements. So if you file a lawsuit, you might be compelled to then go to arbitrate.
Now, what has your experience been with arbitration agreements? How are they working?
So arbitration agreements, unless there's something very wrong with them, are typically enforced. So most employers these days have enforceable arbitration agreements, and if you file a lawsuit, they file what's called a petition to compel arbitration, and the case then is sent to arbitrate. And the difference between arbitration and mediation is a voluntary process where both sides agree they're going to go to a neutral person who will help them see if they can settle the case. It's not binding, so if you don't settle at the end, you just move on with either your arbitration or your lawsuit in court. Arbitration is the same as a trial, except it's not a jury and it's not in the courthouse. It's before a single arbitrator in most cases, and the arbitrator acts as a quasi-judge, and at the end of the day, there's a winner or a loser. So mediation, you're trying to work towards settling the case and moving on, and arbitration is a way of getting a final disposition with somebody winning and somebody losing.
Now, just to remind our audience, the phone number is 661-298-5487. That's 661-298-KHTS, standing for Hometown Station. And the email is dennis@hometownstation.com. Eve, we were talking about PAGA earlier, and that one is a puzzler for most lay people. Why don't you explain it to us?
So PAGA simply stands for the Private Attorneys General Act, and what happened was there is a whole host of labor code sections in the labor code that have penalties if you violate them, but in years past, the only person that could collect them was the Labor Commission. So a private individual could not enforce those. So the California legislature decided, well, wait a minute, we've got all these code sections and people are violating them, but we don't have enough people to go out there and police them. So they came up with the idea, let's privatize this. Let's let every employee step in the shoes of us and become a little private attorney general, and they can enforce the law, and they can do it on behalf of themselves and all other employees who have suffered similar violations and collect the penalties. And the penalties can really stack up and cost a lot of money. So, for example, if someone didn't get a meal break and someone else didn't get a rest break and overtime wasn't being paid right and the pay stub didn't look correct or somebody was misclassified, all these different things. And there's a whole host of other labor code sections. There's over 100 of them that are specified, and then there's just countless other sections that are not listed in PAGA that are still enforceable. In any event, so this one employee, a former employee, makes the PAGA claim. If it's settled or it's adjudicated in favor of the employee, in other words, the employee wins, those penalties are collected and 75% goes to the state and 25% is divided among all of the current and former employees, and the attorney gets the attorney's fees. So it's a way that employees can vindicate their rights on behalf of the state, collect some money, the lawyers get some money, and the state gets some money. The problem with it is it's being used by a lot of people to bring claims, and the penalty stack to a significant amount, because if you add a penalty for a meal break violation, a rest break violation, an overtime violation, a pay stub violation, a misclassification violation, you keep adding these up and you multiply them by the number of employees, it can result in tens of thousands, if not, depending on the number of employees, in the $1 million ranges. So most of these cases end up getting settled, but they're very significant.
And how are the judges reacting to these settlements?
So the judges are not having a good time with these because there's no real rules on exactly what is required for court approval, and all PAGA claims now have to be approved by the court. And you also have to give notice to the Labor Workforce Development Agency. And what happens is, depending on your judge, some judges pretty much rubber stamp a settlement, and other judges treat it like it's a class action, which means they want notice to be given to every single potentially impacted person, and they're given an opportunity to object and show up at a hearing and object. They want all the types of information you'd get in the class action, such as the number of employees, what the potential penalties are, what the risks are in proceeding with the case, and so on. So it's all over the map. As a matter of fact, I just had a hearing in front of a judge recently to approve a PAGA settlement, and the judge said, I wish you'd just dismiss this claim. These things are such a headache. There were other claims that the employee brought that were personal to the employee, plus the PAGA claim, and it was over a pay stub violation. The employer had left out the employee ID number in the last 4 digits of the social, which is a very technical violation since the employee, of course, knows who they are when they get their check. So it's minor, but the amount of penalties were, there wasn't very many employees, so it was around $100,000. So the judge was like, look, I don't even care about the PAGA claim as a technical violation. Why don't you just dismiss it? The plaintiff's lawyer didn't want to dismiss it, so she said, fine. Then you need to give notice to everybody, an opportunity to be heard. I know if you walk down the hall, you'll hear 10 different ways from 10 different judges, but that's how I want it done. So it's rather interesting. So the judges are actually pushing the California legislature to do something about PAGA because it's becoming unmanageable, and it's costing business a lot of money, and ultimately the claims most of the time do not settle for a lot of money.
Okay, we've got a Twitter question from KMAC, which I will ask before we take our break, and we'll answer after we take the break. And the question, I think, is a very, very logical one. It's from KMAC, as I said, which is his Twitter nickname. What if you take an employer to court over an overtime issue, and you lose? Can they fire you? So we'll
absolutely not.
We'll keep you in suspense as to the reasons why, and that they might be doing you a favor. But I agree with our guest, and we'll get back to that issue on the other side. You're on the Legal Line with Dennis Kennelly. Welcome back to the last portion of our show on the Legal Line with our guest Eve Wagner, and the question pending was, what if you take your employer to court over an overtime issue and you lose, can they fire you? And the answer, both Eve and I vociferously agree, is no, they can't. And the reason is that wonderful R word called retaliation claims.
Exactly.
Even if your claim turns out to be a loser, if you're penalized for filing it, that is retaliation. And you're entitled not only to economic damages, which is back pay and potentially front pay, but also punitive damages and damages for emotional distress. So if you're an employer and you want to get rid of the squeaky wheel, you better have good cause to do it, because it's not a good idea if the main reason behind your decision to fire the individual is that he or she filed a claim. I want to thank our guest, Eve Wagner, who has done a terrific job here tonight this afternoon.
Thank you, Dennis.
Eve, why don't you let people know how they can contact you, both your phone number and your email?
Sure. My office number is 310-712-8104, and my email is ewagner@Swattys. It's SWATTYS.com. And in case you're wondering what in the world is Swattys, it stands for Sawyer and Wagner Attorneys, which is my law firm.
Well, that's one of the cooler email addresses I've heard, so I like it. So feel free to contact Eve or myself, and I'll give you my contact information. It's available on my website at Dennis Kennelly, KENNELLY.com. It's got all the information, and we'll be happy to set up a free consultation with you over the phone, and we'll be happy to answer any questions. And Eve, one final thing before I let you go. Explain how the whole rest periods and meal periods have gotten complicated in recent years by both regulations and the courts.
So in California law, non-exempt employees are entitled to meal breaks of at least 30 minutes, and they get two 10-minute rest breaks if they work, let's say, an 8-hour day. And there's been a lot of contention about what it means to give somebody a meal break and whether they need to be relieved of all duty, and same with rest breaks, and the timing of meal breaks. And there was a California Supreme Court case that came down not too long ago, which is short-named Brinker. And the question in that case was, do employers have the obligation to actually run around and police people and make sure they're actually taking their meal breaks, or do they just need to make them aware and not interrupt or impede them from taking meal breaks? And the Supreme Court decided the latter. They don't have to be watch persons. However, it's still left open the issue of, are employers impeding, discouraging, or not allowing people to take their full 30 minutes. So the meal breaks, cases over that have not really stopped at all. Rest breaks, same thing. There was a recent California Supreme Court case that just came down because there were some employers, particularly where you have a situation of a individual employee or a sole employee on a night shift, for example, so there's no one to relieve them, whether or not the fact that they're sort of on call, even if they're not doing anything during their rest break, was okay. And the California Supreme Court said no, when a person's on a rest break, they have to truly be at rest. They can't have to remain on call in case something happens, even though 99% of the time nothing will happen. So that's the decision that came down recently. So employers need to be very careful about how they manage meal and rest breaks still in the state of California. And employees just need to know what their rights are, which is they are entitled to that 30-minute rest meal break, and there are two 10-minute rest breaks if they work their 8-hour shift.
Now, what's the penalty if you require somebody to work through their meal period or their rest period? What is the penalty the employer faces?
So the penalty is you have to pay one full additional hour of pay. So let's say somebody missed one rest break of 10 minutes. You still have to pay an hour of premium pay. The other issue, of course, with meal breaks is, let's say somebody took a meal break of 20 minutes and they worked an 8-hour day. Well, now they really worked 8 hours and 10 minutes, so they're entitled to 10 minutes of overtime. So they're also entitled to that 1 hour of meal break, but they're also entitled to the overtime pay. Then, because the overtime isn't reflected in the pay stub's not accurate, so you have a pay stub violation. And then what happens is, let's say that employee no longer works for you and you hadn't paid them all their wages because you missed that 10 minutes, they have what's called a waiting time penalty, which is up to 30 days of pay. So blowing it on meal breaks can be a very significant violation.
Absolutely. Well, Eve, thank you very much. We're attending the same event tonight, and I look forward to seeing you there.
I look forward to it, and thank you. Have a good day.
You too. Just so you know, for our listeners out in the Santa Clarita Valley, my next stop after leaving here is to join the Santa Clarita County Bar Association, which is very much like the Beverly Hills Bar Association. It's local lawyers working together to improve the legal climate in the area. I also want to thank, I just got a statistic, we've got 240 views today on Facebook, which we're really happy about. So those of you on Facebook, welcome. And tell your friends, if you enjoyed it, tell your friends. We look forward to having you and them for future shows. Next week, a topic I think everybody enjoys, and few of us, everyone has some view on, but it's certainly a good topic for conversation, and that's sexual harassment in the workplace. So that's next week's topic. We will have one of my colleagues who does a lot of sexual harassment cases, or we haven't decided yet. We may also have someone from the Department of Fair Employment and Housing, who is the state agency that is charged with dealing with sexual harassment laws. So remember the email, dennis@hometownstation.com. We look forward to hearing from you. You can email us during the week, and we'll try and get to your email next week's show. We look forward to it. I want to thank my producer, Laura Espinoza London, and my very capable engineer, the man behind the controls, Aaron Delatorre. So until next week, Dennis Kennelly on the Legal Line.